If you're walking into family court terrified, confused, and wondering, am I about to lose my children or am I about to lose everything? This live Q&A is for you. I'm Tiffany Lesnik, an experienced domestic violence attorney and survivor who has tried hundreds of high conflict custody cases and abuse cases. And I'm joined by Judge Beth Tanner, a respected district court judge who presides over family court and is known for her trauma-aware approach from the bench. Judge Tanner sees the patterns every single day. She sees what helps survivors and what hurts them. And today, she's going to pull back the curtain and tell us what judges actually wish abuse victims knew before court. If you ever wanted the opportunity to ask a family court judge anything, here's your chance. Get your questions ready and drop them in the chat. Today, we're talking about the top mistakes that hurt your case, what actually helps your case if you're a victim of domestic violence, how to reset your legal strategy this year, and why trauma-informed judges matter. Before we dive in, I need a quick favor. Please hit the like button. It helps this message reach other women who need it, and subscribe. If you're ready to stop surviving and start strategizing, we're on a mission to reach 250 subscribers so we can expand this free education and reach more women trapped in the system. And you are part of that mission. So let's get into it. Judge Tanner, thank you so much for being here with us this afternoon. You really, truly are one of our favorite guests.
Well, I love being here, and it's really a privilege to talk with you guys.
Yeah, we do appreciate it. And so we just want to dive right in. So tell us, where are you a judge?
So I'm a judge in District 29, which is Moore County and Hoke County. North Carolina is divided into districts, and I'm in a 2-county district. So I get to travel between the two. It's fun.
And so is that a smaller county, right? Not a large metropolitan county.
That's right. So we're in a smaller rural county area. Hoke is smaller than Moore. Moore is growing quite a bit. I tell people Moore County is where people come to play golf. We have Pinehurst here, and Hoke County is the county right beside Fort Bragg. So it's not Cumberland, but it's right next door.
Okay. And tell us, what kind of cases do you preside over?
So when you're in a smaller area like mine, we do everything. But I am specifically an assigned juvenile court judge. So I hear juvenile delinquency cases when kids get into trouble, and I hear abuse, neglect, dependency cases. But I also am an assigned family court judge. So I handle my very own family court caseload. And then, of course, we hear criminal court and domestic violence, kind of everything else you could hear.
Okay, that's great. And tell us what you're doing to help train other judges how to be more trauma informed.
So in North Carolina, there's been actually a really great project. It came all the way down from the Chief Justice that new judges now would have to get trauma-informed training. And we all got that, starting with my new judge class. In addition to getting that training, I implemented some things in my courtroom that have gotten some attention. Things like planning meetings with attorneys before court, so we make sure that we know when people's cases are going to go. Things like, how do we organize a court day and what do we talk to folks about? And so I've been invited to be on panels to talk about that, because it does really help not only the attorneys and the courtroom staff, but it actually helps the people involved in their cases, because we're able to really give them time and dedicated time when they're supposed to be there.
That's awesome. And why is doing trauma-informed training for the other judges in the court system, why is that important to you?
So I think what we know now about trauma that maybe we didn't know before is that trauma shows up in all kinds of ways. So when you have a good plan for your day, it can help you manage someone's trauma response inside a courtroom, number one. Number two, court is just traumatic. So I think there's this idea that we're going to create a space, and we do our best, but the truth is you're coming and people are bringing you their broken things, and that's very stressful for them. We also want to recognize when something's happening inside a courtroom. So someone can be acting very angry because they're under a lot of stress because of the trauma that they've experienced, because they're sitting in the same courtroom with their abuser. And so you want to be informed about that because we're tasked as district court judges with evaluating people on the stand. And I think it's important that we understand that. We're also tasked with controlling our courtroom. And so implementing some tools to help control our courtroom, like being able to recognize when that's happening instead of just saying, oh, you go to jail because you're being ugly to me, is very helpful.
Do you think that other judges are responding well to the training?
Yes. I think particularly in my new judges class, I think a lot of us really understood that and kind of got that training. There are some, of course, just like in any type of profession, there are some people that just aren't going to change. You know what I mean? That's who they are. But I think the reality is when you learn those things, it does give you as a judge some tools to be able to make cases more successful.
Right. And I want to talk about family court awareness is a really, really big topic, right? And there's a lot of talk about abolishing family court in general. In fact, there's a new bill that's been introduced in the state of New Hampshire that suggests that we should abolish family court altogether. How important is it to actually, let me not ask that question. Let's do something else. How are judges elected, or how do judges get into family court in the first place, particularly in North Carolina?
So we are elected in North Carolina, and I think that's really important. You have to be an attorney. So you do have to be an attorney, but there's no rules for how many years you could practice. As long as you're a licensed lawyer, you can run for judge. You do have to run in a political party. So we are party affiliated on our ballot. You can try to get signatures to be unaffiliated. It's very hard to do that. So most people are affiliated. So you go run. We have a primary, and then we have a general election. So we have a primary in March and a general election in November. District court judges run every 4 years. So we are on the ballot more frequently. Everybody else runs every 8 years. So that's kind of why we do that. People choose to be judges for different reasons, but essentially you pay your filing fee and you get on the ballot.
And so 39 states elect their judges to the bench. And I don't think a lot of folks understand this. And so trauma-informed courts start with educated voters, right? So it's really, really important if you want good judges on the bench that are presiding over family court cases, it's important to research your judicial candidates and ask hard questions before you vote for them. And make sure you're voting for them, right? In those really high contest elections, when, the president is up for election and everybody's all inflamed, don't just vote for the president. Go all the way down to the bottom of the ballot. That's where those district court judges are going to be. Those are the people that are making decisions about your children, about your life, and you need to know who you're voting for. So, Judge Tanner, how can voters learn more about their candidates that they're electing for district court judge, for family court?
Yeah. So this is really important. So I actually did some data, which is super. I'm up for re-election right now. So I did some data. We have over 100,000 registered voters in my district. The last time we had an election for a judge, less than 20,000 people voted for that. That's crazy. I mean, that's just it's crazy. And listen, district court judge races are kind of these low budget races. We're not raising hundreds of thousands of dollars or millions of dollars. You know what I mean? We've got a little bit of money. And so I highly recommend going on social media and finding your candidates. You can go to your name as a registered voter at the Board of Elections, and you can already see your ballot and know what is going to be on my primary ballot. Google those names and see what they say. And if they're a sitting judge, make sure you ask some lawyers in the community, hey, what do you think about this judge and what are they doing? I think that matters. The lawyers will tell you what they think. So I think that's important to do. That's how I would educate myself.
Are there particular questions that voters or advocates should be asking about their candidates?
So I would ask about what's important to you. Not every judge is a family court judge. So I'd want to know, are you a family court judge? Do you have experience doing that? I'd ask them what their judicial philosophy is. We all have a judicial philosophy. Politics looks a little different over on the judge side. We can't talk about a lot of hot button issues because we're supposed to, go to the bench like Lady Justice, is blind. So we avoid a lot of those topics, but we have a definite judicial philosophy. I'll give you an example. Mine is that I believe very much in following the law the way it's written. And I believe very strongly in your constitutional rights, that the Constitution says what it says. I don't think it says something that is not written in there. And so that's my judicial philosophy, and I adhere to it very carefully. So I think things like that matter. Another judge might have a different philosophy, that they might believe that over time, the Constitution means other things as we kind of move through history. So you just need to ask, and then you need to decide, how does this fit for me? The other thing I would ask is, what does that judicial philosophy mean in court? So I'll give you a great example of that for me. I think the law says what it says. So if you are petitioning the court for a return of your firearms, and you meet the statutory check marks to have your firearms restored to you, I restore them. There's no question for that. I don't get into the weeds of anything else. I kind of just say, do you meet the benchmarks? That's how I do it. So ask the judge, what does that mean to you in a real case?
Mm-hmm. Okay. And you said you're up for reelection.
Yep.
And as part of that, you actually have a primary runoff in March. Is that right?
I do. Yep.
So
and I'm sorry, go ahead.
Oh, no, you go ahead.
I was going to say, my entire election is going to happen in the primary, and that's actually not unusual. So most voters don't know that. A lot of times, you're going to do your whole election in March, in the judge race, especially local judges, as opposed to in November. So be keeping an eye out, and definitely go vote in your primary elections too.
Yeah, absolutely. And so how can voters learn more about you in your campaign?
Well, I have a pretty active social media. I've always kept a pretty active social media because I think judges ought to be part of educating the community about what we do. So you can find me on Facebook, Beth Tanner for Judge. And I also have a website. I kept it easy, BethTannerforJudge.com.
Okay, BethTannerforJudge.com, and we've got that up here for everybody to see. So one of the things that you can do as a voter, right, if you really want to have an impact on the family court system, rather than abolishing the family court system, because you're still going to have to go in front of some judge, right? We're never going to abolish the court system entirely, is to ensure that you're getting educated about who the trauma-informed, who the domestic violence sensitive judges are, and make sure that you're voting for, you're promoting, you're supporting those candidates. You're getting their information out there to other voters in your area or other people who can support them. And even if they're not in your particular district or on your ballot, there are ways you can support them, maybe volunteering for their campaign, going out and supporting them at the polls, contributing to their campaign, even if it's $10. There are things that you can be doing to actively support trauma-informed judges that will make an impact for families who have coercive control and domestic violence as part of their case. And I know our viewers care very much about those issues. So definitely. Oh, go ahead, Judge.
I would say, I think the way North Carolina is set up is the family court system means there's one judge, one family is what we say. And so that means my cases are mine. And I stick with that family through the entire case. And another thing I'll just say about judges is, not all judges are really excited about family court and domestic violence and juvenile court, So ask, just because they're assigned by the chief district court judge. We don't get to pick our assignments. I love family court. So I do a lot of education in family court, and I really care about that. So those are some other things you can be looking for.
Thank you for that. And we did actually have a question. So we have a question from Tennessee, and she asked, I'm presuming it's a she. If I document the patterns of abuse and neglect well, would it help to bring in academic articles that cite the harm present and future his abuse is doing to the children? That's an excellent question. That's something I get a lot, and people do ask about academic articles, research articles, psychological. What is your opinion on how influential empirical research is?
So one of the legitimate challenges with an article like that is evidentiary rules. I highly recommend to folks, and I know a lot of people are representing themselves, What's more influential than just an article is probably an expert, like a person who can testify in court about that and about your children. You can certainly bring those in and try. And with a judge like me, you know, if nobody objects and it comes in, it comes in. But Tiffany will know that there could be some objections to that. But I think that an expert, more than an academic article, an actual person that knows your children and your family is more influential.
For a woman who can't afford to bring an expert in, do you consider research articles if they're admitted? Do you read them?
Yes.
Do they influence your decision making?
Absolutely. If they're admitted into evidence, I'm gonna read everything that's admitted into evidence. So if it's admitted, I'm gonna read it. It might take me, 2 weeks, but I'm gonna do it. So you know what I mean, to read it all. So I do. And a lot of judges, we have to take so many hours of continuing judicial education. So a lot of times we will actually have reviewed some of the newer scientific literature about things that we're looking at in any event. But yes, I will read them. And that is a great question. Relating them to your particular case is what becomes very important.
Yes. And the one tip I'll give as an attorney, and I'm sure Judge Tanner will probably echo the same, don't overwhelm your judge with too many articles, right? Pinpoint maybe 2 articles that really hone in on the point that you're trying to make. And I would also bring in articles that are current, right? You want articles from the last couple of years, not something from 15 years ago, unless that's the only article on point and it's kind of the gold standard. But yeah, don't overwhelm your judge with just too much literature, because that might have a negative impact on your case. I don't know if you have anything to contribute.
Yeah, I mean, you have to keep in mind, I tell people that, especially in family court cases, I tell kids this all the time, I have to show my work like a math problem. My orders have to have findings of fact. And those findings come from the evidence I receive in court and the stuff I'm reading. So exactly, the more stuff I have to read, the more those important findings can get lost in everything else that might exist. So definitely picking things that are focused and important. I will say, as kind of an interesting point, I do try to keep up with sort of that kind of literature. And I read a book the other day that was recommended to me, What Happened to You? And I go in court the next day, and what's happening in the case was super relevant to something I'd read in that book. And I actually ordered that the parties read one of the chapters of that book in their temporary order, because I thought, well, that'll be helpful.
Yeah. Going back to Tennessee's question.
Yes.
Is it more compelling and more convincing to have the actual evidence or testimony versus maybe expert articles or scientific articles? Or do you think they both play a role or impact your decision making?
I think that depends on the case. I believe that the parents of the children, this is my judicial philosophy, you have the constitutional right to the care, custody, and control of your children. The North Carolina Supreme Court has told us that. So they have said that the parents are the paramount experts in their own kids. You know what I mean? As opposed to an expert, in a really complicated case, I think an expert can be helpful, right? But what is most important, though, to me is what's actually happening with that family. So even like a therapist that maybe is just responsible for doing, a comprehensive clinical assessment can be helpful. So I do think experts can be helpful in the right case, but I overall believe that what the parents are going to come in and talk to me about, they're the experts in their family. You know what I'm saying? So that's what I usually go with.
Right. And Judge Tanner cited to North Carolina law, but parents do have constitutional rights to the custody, care, and control of their children nationally, because that is a Supreme Court decision called Troxel v. Granville that most attorneys are going to know. And that brings up a lot of issues for women in abuse situations, because the abuser has a tendency to get more rights than maybe they're entitled to. Now, what I will say is those rights are not unlimited. right? So there
Correct.
are other cases that limit a parent's constitutional rights to their rights to their children. But that is a precedent across the nation, not just here in North Carolina. So we have a lot of other questions that are coming in. And Brianne, I did see your question. I do need some clarification before we answer it as to where the exchanges are laid out. Are they in a restraining order? Are they in a custody order? Are they not in any order? If you could just put that in the chat so that we could get a better understanding of how to answer your question. And then we have a question that says, hang on, I just lost the question. As a judge, are you able to pick up on covert abusive behavior in the courtroom, such as when the abuser presents as the nice guy? And then let's ask that one first, and then we'll go on to the second part of that question.
So here's what I will say about that. The benefit of one judge, one family is that family is with you for a lot of hearings. And I will tell you, it has been true the entire time I've been a judge, is that they just can't keep that up, but for so long. I mean, that's just the truth. In addition, people who are abusive to their spouse or their children or other people, I say this all the time, they like control in a lot of different environments. And they are not in control in that courtroom. And that will usually be a tell. What I would see is a tell. Abusers believe they're the most intelligent person in the room, the most charming person in the room. That's just not true inside a courtroom is what I would say. And I think that most judges would feel that way. Usually we can see through that. It might take us a hearing or two, but we'll get there, you know what I mean, to see through that. What I will tell you is, and I say this all the time, truth is funny in that you don't have to have a good memory. So when people are lying, they have to have a really good memory. And most of the time they can't keep that up for the pendency of a case. That can be very hard. In addition to that, we're not in relationship with that person. So, you have been in a personal, intimate relationship with this person. You share children and a home. We don't have any of that. So, they just aren't impacting us in the same way that they've probably impacted you in that personal relationship. It makes it a little easier for us to see through it.
Right. And I think Judge Tanner makes a really good point, again, talking about family court and whether we should abolish family court or keep family court. Having one judge to one family allows that judge to really get to know your family. If we abolish family court, you're going to get who you get, and you're not going to be able to get upset, right? It's going to be whatever random judge happens to be in general court or district court that day. And he's going to get a do-over, right? Every single time you go to court, potentially. So there is a benefit to having the same person preside over your case every single time, because they're going to see those patterns of behavior. Even if the first hearing or two doesn't work in your favor and you're upset about it, things can change down the road. So I do think that that's a benefit.
I agree.
Yeah. And so there was a second part to that question, which was, okay, so if you're picking up on whether it's covert, I think covert is the hardest one to detect, but if you're picking up on abusive behavior in the courtroom, how does that affect your decisions? And I don't know if you can answer that or not, but if you can, we'd love to hear it.
So I think what's important to recognize is when we talked about those constitutional rights, they were true. So sort of where I start when at the beginning of a case thinking, all right, everybody has equal rights to these children. But then evidence like that changes those equal rights because we have discretion and we just have to explain why. So things like that can modify what I might decide in a case. So I'll give a great example. Sometimes when you're creating a schedule with children, if a parent is using control, they might use that child, the meeting place or decision making inside that. So if I see that in a case, for example, I'm never going to leave open for them to decide where the meeting place is. I'm going to decide it because I can see in that case that this person is trying to use all these little decisions to exercise control. I might decide to give a parenting coordinator in a case when I see something like that, because it gives a parenting coordinator is usually an attorney. And a lot of times they are able to see through it too. They're usually a family law attorney, and it can help in keeping this person that wants to use every situation to control their spouse, kind of taking away that control from them. But that's what happens. Practically speaking, it just impacts their ability to have custody, and it also impacts how many times I'm going to allow them to interact at all with the other parent.
Right. So is a person's behavior in court evidence?
Yes. Yeah. The court tells us that. So we are actually, as district court judges, we are the law people, and we're also the finder of facts. So we make the decisions. And what the Court of Appeals and the Supreme Court in North Carolina has said is that we're actually the best people to know and evaluate the witnesses on our stand, because we're sitting there with them. So absolutely, it can be evidence. Yep.
What about if they're not on the stand yet? What if they're, sitting at counsel table, or maybe their case hasn't started yet, but they're kind of rambunctious or engaging in some behavior that you take notice of? Does that affect your decision later on?
Yes. Yeah. We
unusual.
can use all of that. Yeah, we can use all of that. So that's kind of the case that talks about that actually talks about the fact that what was happening in the courtroom was relevant to the judge's decision. So I think that is important. Yeah.
Okay, that's great to know. So ladies, like your behavior, the minute you walk into that courtroom, his behavior, the minute he walks into that courtroom, will have an impact, or could have an impact on the outcome of your case. So take note of that. That's great information for us to know. So we have another question. Once a domestic violence protective order or a restraining order has expired, what type and level of abuse or harassment is necessary to win, I guess, another restraining order? And that's going to vary by state.
It is.
Yeah.
In North Carolina, we renew domestic violence protective orders. So as long as when the domestic violence protective order can last for up to a year, as long as you file a motion before the expiration of that year, that's really the only kind of legal thing. Basically, what the case law says is you can have a renewal. It's very odd to deny a renewal. It would be very unusual to do that. It doesn't require a new act of domestic violence, which I think is very important. So because essentially, right, that would be very hard. You're a survivor, you've gotten away from this person. So why would there be a new act? But you still want that protection. So there can be all kinds of things. And it really doesn't, I just had that to court yesterday. And so it really doesn't require much of anything, at least in North Carolina, to get your renewal. However, you need to be aware that custody provisions that might have been put in place in your domestic violence order cannot go beyond a year. So you have got to get your case into family court land for custody. You can't just hang tight on that domestic violence order.
And that's relevant to North Carolina.
Correct.
Different states are going to have different timelines. Like there are many states that will put domestic violence protective orders in place for much longer periods of time. They'll also have custody provisions that last much longer periods. So it just really depends on where you live. And a great resource to find out your domestic violence laws in your state where you live, and I'm going to pop that up on the screen, is womenslaw.org. You can learn all about all of the custody statutes and all of the domestic violence laws in your state by going to that website. But generally speaking, I've done a lot of research through the American Bar Association on domestic violence in the United States. One thing that I think women misunderstand is that domestic violence, generally speaking, across the United States is not just physical abuse.
Correct.
Right? The states have much broader definitions of what constitutes domestic violence, and that includes even attempted physical abuse. And physical abuse is not just him putting his hands on you. It could be, him throwing things, his breaking things, him being physically aggressive towards you, maybe driving recklessly in the car, with you being in the car with him. In North Carolina, it even includes things like a sexual assault, or rape, which definitely is a form of physical abuse, in my opinion. And then continued harassment, that I'm not going to use the legal terminology because it's different in each state, but continued harassment that just makes you feel like you are sick, right? You're walking on pins and needles. You can't sleep at night. You're jumpy. You need to see a therapist or go to the doctor, something like that. You've lost your appetite. You're getting headaches. Any kind of behavior like that, him blowing your phone up, texting you nonstop, threatening you, calling you names, cussing you out, following you around, whatever that be. Those are behaviors that would constitute filing for a protective order. If you do not feel safe,
right,
I would seek the advice of an attorney or go to your local domestic violence agency and ask about filing for a restraining order. It's always better to err on the side of caution.
I want to note one other thing about that is in North Carolina, I know for sure, and I do think this is true in most other states, threats to commit suicide are domestic violence. So if an abuser is saying to you, well, I'm just going to kill myself if you don't do X, Y, and Z, or, or I'm in the family home and you're having a disagreement. He's like, well, I'm just going to kill myself. Or she's like, I'm just going to kill myself. That can be a reason that we find domestic violence. That is a reason to find that. And if that threat is made and the threat is made with the threat of the use of a firearm, that could be actually a reason to remove firearms. So really be aware of all those opportunities.
Yeah, absolutely. All right. So we have another question from Brianne. Yes. And so Brianne is having an issue with exchange locations, and she wants to know how to get it changed quickly, although I'm not sure that that's her solution. So she has a custody order in place that says her exchange should occur at the local REI, which is like a sports hardware store. It's a local store, right? And so exchanges are supposed to take place at the REI. Her ex will not meet her inside REI or at the door, and his behavior is escalating. He puts conditions on her as to where to walk, park, etc. Do you have any recommendations for Brianne?
So I won't give you independent legal advice in your case, but here is what I would say. I think that is one of those issues where you probably have to address it in court with your judge about we're having a challenge we picked a place and now that place isn't kind of good enough because there's all these other pieces to it. And so we really need some real details around where, you know what I mean? Like at the front door. And that is an example of a place where if I heard that there was a challenge with that, I would be very specific. You're going to meet at the front door at the REI at this time. You know what I mean? That's kind of, as a judge, if I heard that, that's what I would do. A lot of this revolves around, is this a temporary order? Is it a permanent order? What does that look like? And one of the things I tell people that I think is so interesting is how detailed family court orders can get when you have challenging opposing parties, because really, I mean, the judge could write 100 things for y'all to do if that's what we needed to do. But yeah, you just have to address that with your judge. I will tell you, when you're addressing issues like that, I can sense that could be very frustrating, but just keep yourself in line. Hey, we're struggling with this because it seems like we can't figure out, do we meet at the front door? Do we meet, you know what I mean? And I tell people that because you can be very frustrated. Try very hard not to bring that into the courtroom. One of the things I say all the time is sometimes you just always have to be the adult in the room. So just kind of always be the adult in the room.
Yeah. A couple other things. I mean, if your order is clear, you could always file for contempt. Like if he's not, your order is there to protect you. So follow your order. And if he's not following it, you could file for contempt. You could also file a motion to have a parenting coordinator appointed who could enforce those provisions. The other thing that I recommend, which is a simple, maybe quicker strategy is reach out to him through your communication app or text. I don't know how you guys communicate, and say, hey, we really need to pick a place where we're going to meet. And I want that to be consistent, and see if you can nail him down in writing. And then if he keeps violating that commitment that he's made in writing, you could use that in a future hearing to show that he's the problematic parent. So just some tips there. But as far as doing it quickly, getting into court, I don't know about in Judge Tanner's courtroom, but in the larger metropolitan courtrooms, it's going to be a few months before you can get that resolved. So if you feel like you need to file a motion, you need to do that sooner than later, because we're looking at like at least 3 months where I am. How long does it take folks to get in the more rural counties, Judge Tanner?
We can probably fit you in as what we call a backup. And we usually get to our backups, you know what I mean? So we can probably get you in a month or two, but we only have family court every month. So I only have family court 1 week a month. So that's why that can happen. So that's what I would say. The other thing I'll just add to this is, I would tell you to pick your battles. Sometimes an opposing party wants everything to be a fight. So sometimes just don't fight. If you're going to the REI and he sends you a text like, I'm only going to meet you in the parking lot. Okay, see you there. You know what I mean? Get your kids, live your life. And I understand when that cannot be possible. You know what I mean? So I don't want to not validate that can be challenging. I'm just using that as an example. But I definitely think, keep in mind, and I don't know, Tiffany, you can say what you say about this, but I say this all the time. The first couple of months of a separation are rough. And it doesn't matter if you two were in the best marriage that was ever existed. You know what I mean? And now you just aren't going to be married. It's rough. And then a year into it, 2 years into it, things just can settle down. Not always. So I do want to be clear about that. Not always. But in a lot of cases, that can be true. You've just got to get through that first period. This is a good time maybe to say, I had a podcast the other day and it was about businesses. And somebody was asking me about my family court. And I said to people, marriage is a business. It is the most important business decision most people, but particularly women, will ever make. I've been married for 20 years to my husband, and he is a family law attorney, so he will appreciate this funny. But when I hit the 20-year mark, I've been a dependent spouse, so I'm dependent on him. He makes more money than me. And I said to him, well, I get lifetime alimony now. And it was funny, but that is an example of this is a business decision. So when you're splitting this business up in your family court and your divorce, think of it that way. This is a business decision. Me and my partner didn't work out. We got to split it up. So I do highly recommend kind of switching your mindset a little bit that way.
Yeah, I love that. Before you consider marrying this person, is this going to be a good fit for me financially, right? Emotionally, like if this was a business model, would that be a good choice? What I will say about that, is that you don't want your marriage to operate like a business, though, right? No. If you're in an abusive situation and right. You live on one side of the house and he lives on the other and he has his own set of finances and he keeps everything separated from you, that's not the kind of business we're talking about. No. I think we're saying, like, if you could not visualize yourself with this person because you're not going to operate as a fully functioning business, this is not the type of person that you want to end up being with.
Exactly right.
Yeah. And then, so we have lots more questions. Okay, and one of the questions has an abbreviation of PPP in it, and I'm not sure what that means. So if you could clarify what PPP is so that we can answer that for you. And Pamela asked, if the other parent has household rules you don't fundamentally agree with, is it expected that you should agree to have the same rules to show you are working, you're co-parenting effectively?
So I don't think so. I'm just gonna be honest with you. So different parents have different rules in their house versus my house. The only time that really comes into play is if there is something that a child is doing at one parent's house that's dangerous to that child. So I'll give you an example. Cell phones are a huge issue in family court, right? I have a child that maybe is accessing something on that cell phone they're not supposed to access. It's helpful that mom and dad, even if they're in two separate houses, have the same rules about what we're going to do about this cell phone. Like little Johnny isn't going to have unfettered access to his cell phone on the internet, or we're going to agree to the parental controls on this. However, when I had my kids, they went to my mom and dad's house. And let me tell you about how my mom and dad did not have the same rules that I had at my house. Okay. Kids have to learn how to follow rules in all kinds of different environments. There's different rules at school than you have at your house. So I think it's helpful when parents can work together on a real issue, like what I've just talked about, like accessing pornography. But outside of that, if dad's rules are that when you come in, you take your shoes off at the door and you do, you can be very, stringent. And I will tell you, I have a number of military cases where one parent is in the military and the other parent is not. And when they split up, I will tell you, the military member's house is always a lot more stringent than the other parent's house. And I think kids just have to learn to navigate that. Now, that is not to say that rules that don't make sense aren't something that can't be relevant to the parenting time that person has, right? So a rule that is, harmful to little Johnny, that's at dad's house or mom's house is something that might be relevant to how much time that person gets.
Yeah. And I know, especially with abusive men, right? That's another way that they try to control. One, they have overly authoritarian rules, or they have unreasonable restrictions and rules. And then they want you to put that in place in your home. And then they accuse you of not co-parenting with them if you refuse to do that. I think it's absolutely fine to have rules in your home and rules in his home. We call that parallel parenting.
Correct.
Right? You're not letting him infiltrate your home. And I think that can reduce the conflict as well if you have your own rules and he has his. Otherwise, he's always keeping tabs on you. Are you instituting my rules, or you following my rules? And I think the reduction in conflict is more important than trying to look like you're co-parenting, but it's just increasing the conflict. I don't know if you have any comments on that, Judge Tanner.
No, and as a judge, I will tell you that I don't think it's that big of a deal that mom has different rules than dad. I just don't. Again, like I said, unless there's just like some specific thing going on or there's something harmful that's happening at the house. But yeah, people have different rules. You got different tolerance levels. You got different things going on in your life. That's how it works.
Yeah, absolutely. I want to talk, and we have some more questions, so I'm trying to follow them all in the chat. We got a lot going on in our chat. I'm so happy to see that. So happy for everybody to be here. We welcome you. We're glad you're here. I did want to talk about you. We talked about, you said this phrase multiple times, like one family, one judge. Mm-hmm. And I know I've had some ladies that have talked to me that don't have good outcomes with their judge, right? And they get really frustrated and they want to change that judge and they can't. And I think that's where there's a lot of dissatisfaction with the family court system because they feel like they're stuck. Mm-hmm. Can you give any tips for people that are in that situation for how they can improve the outcome of their case later on with that same judge? Some tips for behaviors or things that they could be doing that would help them find more favor with the court.
Yes. So if you have an attorney, that attorney probably appears in front of that judge all the time. So I would have a really frank conversation with that attorney about this very thing. Judges all have things that are really important to them. I will give you an example. I find a child's academics to be very important. If children are not successful in school, they cannot be successful in life. Now, that doesn't mean they got to be a straight A kid. It can be all kinds of things. They can go to a trade school. They can go to all of that. But I want to see that we're actively parenting in that way. Also, listen really carefully to what your judge is saying, talking about, and putting in your order, because that's what matters to them. We don't have to put everything in the order. And listen to what questions they ask. In our jurisdiction, I can ask questions. And I say this often. I say that the attorneys ask questions and then the court asks questions. And I can assure you that if I'm asking a question, I think it's really important. So listen to what's happening and lean into that. What is your judge thinking is important, and really think about that. listen, you're not going to agree with everything that a judge. I know somebody's leaving my courtroom unhappy. There's no way I can please everybody. That's how it is. Because you're deciding, but you need to really lean into what it is that they think is important. That's also a good litmus test for you. I'll give you an example. It is very important to you, I am sure, that, over the course of a decade, there have been all of these things that have happened in your marriage. But if your judge is not ever making findings about that or talking about that, you need to leave that and figure out what's important for that judge and go at it from that angle.
Mm-hmm. Yeah, that's a good point. There's a lot of things that are very important to us, right?
Mhm.
That we feel like we need to share that story over and over, and it's just not that important to the judge. We need to focus on what matters to them, right? And that's the narrative. I don't say narrative in like the fake sense. I mean, that's the information, the evidence that we need to be presenting to them, because that's what they care about.
That's right.
Okay. So we have more questions, but okay. Let me see what we've got here. Yeah. Let me ask you a couple of the other questions that I had. Is there any type of evidence that you find more compelling than anything else?
So, I think that is kind of dependent on the case once again. So here's what I would say that's compelling. I always think that kind of a third party, like not the parents, you know what I mean? And I don't just mean like, your mom or your dad, but people who are involved in the day-to-day life of your family. So I'll give you a great example. Sometimes like a neighbor is really close to that family. And they kind of come in and they have some information about what's going on with that family. I think that can be very helpful information because usually I get it. Usually they're friends with you or friends with them. But most people, when they swear, they're going to tell the truth. And they're just a neighbor and they're not personally involved in that case. They're going to get up there and tell the truth. So I do think that can be very good evidence. I also think that professionals who may be involved in a case can be very good evidence. So, teachers at school, those kinds of things can be very helpful evidence for seeing what is actually happening with a family. I do think those are good pieces of evidence.
Yeah, that's great. Is there a worst thing or something that a survivor or victim of domestic violence should not do in court?
So, I don't know if there is a worst thing, but I think I see that is very challenging is when people get lost. What I would say is lost in the sauce. They lose the forest for the trees. Think about why you're there. So let's say you're there for a custody case. You are there for a custody case. The question is, what is in the best interest of your children? The dispute y'all had a decade ago just doesn't matter. And it doesn't mean that it's not important. It just means it's not important for that determination. So getting lost in that. The other thing that I think can be very damaging is thinking that you have to be perfect. Nobody is perfect. I sometimes will listen to a family court case. I'll give just a hypothetical example. And somebody will say, oh, well, mom was home with the kids at the pool and she was drinking wine with her friends. And I'll literally in my head go, I did that Saturday. So, you know what I'm saying? So you don't have to, or mom was yelling at her kids. I have totally yelled at my kids. So you don't have to be a perfect parent and you don't have to be a perfect person. And the fact that you're not perfect doesn't mean that someone gets the right to abuse you. I've yelled at my husband. He can't haul off and slap me. That's not a thing. You know what I'm saying? So I think maybe just knowing that when you go in and always tell the truth. If you lie, that will impact your case. So maybe that is the one thing. Don't lie. Just be honest about it. It's okay. We're human. That's how the world works. Nobody's perfect. I'm human too. That's why I have the Court of Appeals that tell me when I get it wrong. But everybody's human. So just know that. And we know you're human.
Right. And I tell my clients all the time, if you can admit to bad facts, right? If you can admit to things you've done that you shouldn't have done, the judges I feel like the judges are looking at you like, wow, if they can admit to that, I can believe what they're telling me.
Right.
So one of the other questions that came in was, it's a part 1 and part 2. So she just finished a custody trial and she doesn't feel like she proved her case, or that there was abuse in her marriage. Earlier in the marriage, he had more clear abusive behaviors that changed to more covert behaviors over time. They were married 13 years and had children well after the bigger abusive incidents occurred. He still has aggressive behaviors toward me. Is it too late to file for a DVPO or a restraining order? I feel incredibly unsafe at times.
So I think, again, that's just going to depend on your state. The DVPOs are usually about the relevant time period that's happening right now. But in North Carolina, it's important to note that being a former spouse or a former partner still puts you in domestic violence land. That's what the law tells us. So, I mean, if you're at a hypothetical, if you're at a custody exchange and he's doing something, or the woman is doing something that's abusive to you, you still qualify for a DVPO. You share children together, you were in a former relationship, you can still qualify. The independent facts, you'd have to look at that, but it's never too late. Now, something that happened 10 years ago, it could be relevant to a history. That's what I would say. You can use that as relevant to a history of domestic violence, which can help explain why this particular incident might be, more concerning than it appears on the surface. I do. And that's in the case law. So.
Mm-hmm. Yeah, I think the judges are looking for imminency. Like, are you in danger right now? What's happening presently? And I'm not sure when you had your last trial in front of your judge, but if it was recent, so like within the last few months, and the judge made specific findings or said something out loud that they didn't believe there was domestic abuse, and then you're going to have that same judge if you file for a protective order. You might be better off waiting until there is a large incident that occurs where you have witnesses or someone else that can back up that behavior, because that judge might not be inclined to grant the protective order. Always err on the side of caution. If you really feel unsafe, I say file the domestic violence protective order, restraining order, call 911. Do what you need to do to be safe. That is the priority. But from a legal strategy perspective, if you've already been in front of a judge recently and they seem to be leaning in there's no DV and your evidence is pretty old and nothing dramatic has happened recently, you may want to wait. You said his behavior maybe is escalating. Wait until that next event before you file, because the goal is we want that order of protection to be entered, right? Because when we file orders of protection and they're not entered, then it can be used against us. He's going to say, oh, you filed a false DVPO against me. And we certainly don't want him filing for sanctions or attorney's fees because you filed a frivolous complaint against him. So we want to protect you in that way as well. So another question, can affidavits be helpful as forms of evidence?
Yes. So in North Carolina, and I'm sure in other jurisdictions, actually temporary hearings can be done by affidavit totally, at least like in our family court rules. Make sure you read your family court rules. That is a good important point. Every single district has different little family court rules. They're online. You can find them. Go find them. So take a Google through, if it was Moore County, family court, and you'll find those things, or Hoke County family court. So they can be helpful, I think. But affidavits still have to be based on personal knowledge of the affiant. And I say this all the time, which I think is kind of interesting. So if somebody's just like, well, I heard from so-and-so that this is the thing that happens, I'm not going to admit that probably, but It's also just not helpful. So what this person has personal knowledge of is what is important, and it needs to be relevant to your case. But sure, yeah, they can be helpful for sure.
Yeah, and that's absolutely true. Like in my jurisdiction, we can't use affidavits anymore, at least written affidavits from witnesses. And there are financial affidavits too. So
Yes.
you could have a verified document that's got like your budget on it or a list of your property. So there are a difference between the two. I find them helpful as an attorney when my clients provide them to me because they're good witness statements. So they let me know who I need to contact, who should I call in order to bring them into court as a witness. So I don't think it's a wasted exercise, even in areas where they don't have they don't allow affidavits to do that so we can find out who the good witnesses are. All right. So I want to address a couple other questions.
Sure.
So for women who are terrified to come to court, right? They don't want to face their abuser. They don't want to face a potential outcome. What happens in your courtroom and maybe in most courtrooms if a litigant does not show up for a hearing?
If a litigant does not appear and they are the moving party, so they're the plaintiff is what we call them. So they're the one that's asking for something. The case is dismissed if they do not come for failure to prosecute. That's what we call it. If they are the defendant, if they're the person on the other side of the litigation, the case essentially proceeds without them, especially in civil court, which is what we do in family court and even in domestic violence, that's civil. So we proceed without them and there's no evidence on their behalf. One of the really important things for folks to understand is that judges are bound by the evidence we get in the courtroom. Okay, so I can't make it up. I can't go outside and do my own research. I'm bound by the evidence I receive there. And so if I don't get it, if you don't come, I don't get it. Listen, court is scary. I mean, I don't want to like downplay that. It can be very scary, but there are opportunities for you to make it better. You can ask for a support person to be there. If you're in domestic violence court, there are groups that bring a support person there. You can ask, like, for example, if the domestic violence group that was here in Moore County said, I have someone, but she would like to wait outside in a room with one of us as opposed to sitting in the courtroom, we can make that happen. So there are things you can ask for. Don't be afraid to ask for some accommodations. That's a little harder in family court than it is where there's like a system, like in domestic violence court, with a group who's there all the time to kind of support folks.
Right. And yeah, ladies, my experience is if there's a hearing and you're not present and they have it without you, the judge is usually going to give the abuser whatever they're requesting, right? So if they're asking for full custody, they're probably going to get it if you're not there. So it's very, very important that you're present. Don't not show up because you're afraid. What if there's like a medical issue, like a medical emergency or transportation issue, something like that? Is calling the clerk or sending an email to the court sufficient for simply not showing up?
The answer to that is no. Usually, does it happen? Sure. So when there's a medical, I mean, listen, I have certainly gotten a call that we come in that morning for court and the clerk calls and says, hey, so-and-so has been transported by ambulance to the, hospital. I mean, I'm going to give you a continuance for that. I'm not, what I mean? I'm not going to kind of question that a whole lot unless there's something going on that I think maybe that's not honest. But yes, it's not, that's not what you need to do. You need to file a motion to continue. And you need to support why do I need that continuance? And stuff does come up. I mean, that's not crazy. You know what I mean? But you do have to file those motions, and just calling the clerk or even emailing the clerk can be a reason that it can be denied. But of course, there are those situations where there is a true emergency. For example, we've had the flu really bad around Moore County recently. If somebody sent in a thing that said, hey, I've got the flu, I do not want you with me. Thank you. We'll see you next time, so.
Yeah, absolutely. And I don't remember what I was going to say. It just kind of went, we're about out of time, but are there things that someone can do? Let's say they did have a medical emergency. Can they ask you to reconsider your ruling if they can provide the proper documentation at a later time?
Yes, they can.
Okay, just so everybody knows that.
Yes.
And then we had one final question. I think we can maybe do that, and then we'll wrap it up. So if you felt like there's coercive control and you agreed to a permanent parenting plan, you maybe didn't have a lawyer that advocated for you so well, and they kind of pushed you into an agreement that really isn't working very well for your children, is there anything that can be done to change that permanent custody order?
Okay, if it's a permanent custody order, so there's a couple things that could be going on. If it's not an order, if you've just written down an agreement with somebody, that's not an order. The court always has jurisdictions to start a custody case. If it is an order, we call that modification. If it's a permanent order, so there's two things that can happen. You can have a temporary order, and that you can just ask for a review. You can ask for a review of that. That's fine. If it's a permanent order, you have to be in modification land. And what the law tells us is that there has to be a substantial change of circumstances that substantially impacts the welfare of the minor children. That can feel like a big hurdle, but I'm going to tell you why it's a big hurdle. Because we want permanency for children. That's what we want. We don't want them to have a different plan every other minute. We want permanency for them. So I really highly recommend, if you have a modification case, I can tell you what the law says, and that's what the law says. You should get some legal advice about that.
And ladies, what I will say is you are your children's biggest advocate. I know that it's scary, but especially when you're in court or you're in mediation, this is your opportunity to stand tall and stand strong for those children, and you can do it. You are their mama bear. You are the one that's going to fight and advocate for them. And so this is your opportunity, regardless of how scary it is, to do that. And so I am so thankful for everyone's participation today. Judge Tanner, thank you so much for your time, your wisdom, and your willingness to have these honest conversations. We just really appreciate you. It means more than you know to the women watching who often feel invisible in this system. You show us what it looks like when someone on the bench truly understands trauma, power imbalances, and what's really at stake for families. So thank you. And if you want to support, yeah, absolutely. If you want to support Judge Tanner, again, her website is up on the screen, and she also has a Facebook channel where you can check her out. What is the name of your Facebook?
It's just Beth Tanner for Judge, so you can find it pretty easily.
Okay, great. And to everyone watching, this is why your vote matters. Judges like Judge Tanner don't just know the law, they understand people and they understand trauma. And so if we want a family court system that actually protects women and children, we want to support trauma-informed, child-centered judges. So that means get educated, show up to your local elections, use your voice in the judicial process and in the elections. So please research your judicial races and support candidates like Judge Tanner who believe in safety, fairness, and dignity for survivors. This is how we change the family court system. And so please support Judge Tanner by visiting her at www.bethtannerforjudge.com. Remember to like, subscribe, and support this channel. And before you log off, do me a huge favor. If you'd like to be entitled to win one of the free registrations for my 12-week legal coaching groups for women going through post-separation abuse, type win in the chat or in the comments, share this video with another woman who needs to hear it, and hit the like button. We are so glad that you joined us today. We do a Live Free Legal Q&A every month, the third Thursday of each month. So we will hope you will join us again next month. To every woman watching, you are not alone, you are powerful, and you too can learn to conquer your Goliath in court. We will see you next time.
Thank you all so much.